on safari retreats judgment has been set aside by the Supreme Court. Generating rental or there is a lease income from those immobile property. Plant or machinery is not provided intentionally under section 17, whereas revenue in its order did not allow the assessee to take input tax. Why was the input tax credit allowed by Orissa High Court in the first place? My dear friends, this had a huge impact in the corporate India. Many of them who constructed immobile property based on safari retreats case is whether there is a scope for legislative overruling. It is not a drafting error by the lawmakers who intended to pass this law, but it was a conscious decision to replace. My dear friends, the review filed by the revenue on safari retreats judgment has been set aside by the Supreme Court. My dear friends, we all know about the famous judgment of safari retreats with respect to Goods and Service Tax Act. My dear friends, it is a case of section 17 subsection 5 clause D. For the benefit of all of you, I thought it is very important that I read the exact words of section 17 subsection 5 clause D from the bare provisions of the GST law. My dear friends, under section 17 apportionment of credit and blocked credits, under subsection 5 dealing with blocked credits, it is clearly provided, notwithstanding anything contained in subsection 1 of section 16 and subsection 1 of section 18, input tax credit shall not, very important, input tax credit shall not be available in respect of the following. Namely, section 17 subsection 5 provides for, notwithstanding anything contained in subsection 1 of section 16 and subsection 1 of section 18, input tax credit shall not be available in respect of the following. Under that, clause D provides for a very important aspect concerning blocking of credit with respect to input tax credit. Clause D provides for, I quote the exact words of the bare provision: goods or services are both received by a taxable person, goods or services are both received by a taxable person for construction of an immovable property other than plant or machinery on his own account, including when such goods or services or both are used in the course or furtherance of business. For this purpose, there is an explanation provided. For the purpose of clause D, clause C and clause D, for the purpose of clause C and clause D, the expression construction includes reconstruction, renovation, additions or alterations or repairs to the extent of capitalization to the said immovable property. My dear friends, for this, there is a explanation provided under section 17. It clearly says, for the purpose of this chapter and chapter 6, the expression plant and machinery means apparatus, equipment, machinery fixed to earth by foundation or structural support that are used for making outward supply of goods or services or both, and includes such foundation and structural supports but excludes land, building or any other civil structures, telecommunication towers, pipelines laid outside the factory premises. My dear friends, now that you have understood section 17 subsection 5 clause D with respect to block credit of the input tax credit concerning plant or machinery, there was a landmark judgment of the Supreme Court in case of Chief Commissioner of CGST versus Safari Retreats Private Limited. My dear friends, it provided relief to many taxpayers, which allowed the taxpayers who have incurred expenditure with respect to immovable property, and there is a furtherance of business using that immovable property, like generating rental or there is a lease income from those immovable property. My dear friends, literal interpretation of section 17 subsection 5 clause D, you may assume that the input tax credit is not available. But very important point to be noted under section 17 subsection 5, there is a difference between section 17 subsection 5 clause C and section 17 subsection 5 clause D. What is the difference? In section 17 subsection 5 clause C, the words used are plant and machinery, whereas under section 17 subsection 5 clause D, the words used are plant or machinery. By the way, the definition of plant and machinery is provided as part of the explanation to section 17, but whereas plant or machinery is not provided intentionally under section 17 of the CGST Act. With this matter in hand, the Safari Retreats went to say they are agreed by the order of the revenue. Safari Retreats went and filed a writ petition in Orissa High Court, and Orissa High Court decided in favor of Safari Retreats. And they said Safari Retreats is eligible to take input tax credit concerning the immovable property, because immovable property is used for furtherance of business. But whereas section 17 subsection 5, whereas revenue in its order did not allow the assessee to take input tax credit under section 17 subsection 5 clause D, stating that for all the immovable property, whether involved in the furtherance of the business or not, whether it is used for the personal use, as the term plant and machinery is used or machinery is used, the input tax credit cannot be allowed. Accordingly, agreed by this order, the Odisha High Court gave the judgment in favor of assessee, saying that they are eligible to take input tax credit because the words used under section 17 subsection 5 clause D is plant or machinery, and that immovable property is used for furtherance of business. There is a further supply from the immovable property. Accordingly, input tax credit has to be permitted to be taken by the Safari Retreats. Why was the input tax credit allowed by Orissa High Court in the first place? My dear friends, the Orissa High Court observed that the Act aims to provide uniformity in the levy and collection and prevent double taxation. My dear friends, when you go and check, the intention behind the GST law was to avoid cascading effect. And wherever there is a cascading effect, the courts have taken an effort to see to that the input is made to be allowed to the assessee. Here, in this case, the order that was issued was under section 74. Section 74 is an order passed when there is an invocation of section 69 along with section 132. So, classifying the assessee as a fraud. Whereas, my dear friends, it is an interpretation issue under section 17 subsection 5 clause D between plant or machinery and plant and machinery. For plant and machinery, there is a definition. For plant or machinery, there is no definition. According to the immovable property used for business, the input tax credit has to be taken is the stand taken by the assessee. Accordingly, invoking section 74 cannot be held to be lawful. Accordingly, Orissa High Court ruled in favor of the assessee and the revenue went to the Supreme Court. Supreme Court also ruled in favor of the assessee, considering the fact that section 74 cannot be invoked with respect to section 17(5)(d) because there is no clear definition. But however, the Supreme Court in its ruling declined to hold the provision as ultra vires of the Constitution because it is a legislated act. Accordingly, the point to be noted here is whether the input tax credit is allowed to be taken or not. To that extent, limited extent, the judgment was pronounced to say input tax credit can be availed by the assessee. And the next important point that came up before the Supreme Court was, the question of law was whether building can be considered as a plant. As there is a definition of plant and machinery only, as there is no definition of plant or machinery, it was stated by the Supreme Court, observed by the Supreme Court, that building can be considered as a plant provided it is used for furtherance of business and it is to be put for functionality test whether the building is used for furtherance of business or not. Only when it satisfies the functionality test, then the building can be classified as plant, and that too to case basis. The court also further observed that when a property is used for further supplies, such a renting or accommodation services, sale or license, the same cannot fall under the expression on his own account. Accordingly, the input tax credit was allowed by the Supreme Court. My dear friends, the foundation of the rule of law is that the courts are final arbiter in matters of statutory interpretation. The matter here before the Supreme Court was with respect to interpretation issue. The interpretation issue was between plant and machinery under section 17 subsection 5 clause C and plant or machinery under section 17 subsection 5 clause D. Accordingly, the final arbiter in matters of statutory interpretation is the Supreme Court, wherein the Supreme Court went on to interpret to say building will form part of the plant provided it satisfies the functionality test. Accordingly, the input tax credit can be allowed provided the functionality test is satisfied on a case-to-case basis. So, court of law is the final arbiter with respect to the statutory interpretation of the legislative intent. My dear friends, however, the Supreme Court judgment which came in favor of the assessee was short-lived until the time when the GST Council, as part of 55th GST Council, however, the relief that came for the assessee, especially safari retreat, was short-lived because GST Council in 55th GST Council meeting, GST Council in its 55th meeting said and recommended for an amendment in the GST law itself, wherein they wanted to replace plant or machinery under section 17 subsection 5 clause D, which gave relief to the assessee to avail input tax credit, with plant and machinery, which is already defined under the section 17 of the CGST Act. And this was proposed and was brought under clause 119 of Finance Bill 2025, wherein under clause 109 of the Finance Bill, they replaced plant or machinery with plant and machinery. Accordingly, input tax credit which was availed by safari retreat and similar assessees were disallowed. My dear friends, this had a huge impact in the corporate India because many of them who constructed immovable property based on safari retreat's case, they went on to avail input tax credit. Further, they did not choose to take the depreciation benefit under the Income Tax Act. Now, because of the amendment brought by the Government of India as part of the GST Council recommendation in Finance Bill 2025, has put the assessees into hardship, wherein they are also denied the input tax credit. Also, they are denied the benefit of depreciation under the income tax law because they relied on the Supreme Court judgment, which is the law of the land on the date of pronouncement, until the amendment came in. So, my dear friends, this retrospective amendment, whether is constitutional or not, should be tested in the court of law. As of now, the position of law is that post-amendment, input tax credit cannot be taken on immovable property, whether it is used for own personal purpose or furtherance of business. Considering the fact the words plant or machinery is replaced by plant and machinery, for which the definition is provided under section 17, which clearly disallows input tax credit. My dear friends, the next important question that you will all ask me is whether there is a scope for legislative overruling. My dear friends, there is a Supreme Court judgment that came in and immediately there is a legislative overruling, and the interpretation brought by the Supreme Court is nullified by the amendment brought by the legislative overruling. What is the situation in those times? My dear friends, the principle of legislative overruling decisions of the Supreme Court is fairly settled in many cases. But to summarize, unless the amendment to the underlying law is manifestly arbitrary or falls to cure the defect identified by the court, it would amount to usurpation of judicial powers and hence could be unconstitutional. The question here is whether the amendment to replace plant or machinery with plant and machinery is arbitrary and is also usurpation of judicial power is the question of law that need to be tested in the days to come. However, my dear friends, this drafting error as claimed by the revenue may not be a drafting error, considering the fact in the GST model law as part of, considering the fact that under section 16 subsection 9 clause D, under the GST model law, plant and machinery was used even in the GST model law. But whereas intentionally it was changed as plant or machinery, that means it is not a drafting error by the lawmakers who intended to pass this law, but it was a conscious decision to replace plant or machinery in the place of plant and machinery. Now, because of this legislative overruling, whether it has amounted to arbitrariness and usurpation of judicial powers is the question that required to be tested. We have to wait and watch what more developments will happen surrounding safari retreats. But however, the review petition filed by the revenue before the Honorable Supreme Court was dismissed, and as there is no error in the order. But however, input tax credit cannot be taken by the assessees across the country, considering the fact that safari retreat's judgment has been reversed by the legislative overruling. Thank you so much.